Bismillah ar-Rahman ar-Rahim. Good morning, dear students. Today we shall complete our discussion regarding penal treatment, chapter 3. Today we shall discuss or complete our discussion regarding um, uh, holding a comparison between probation and parole, the required conditions of parole, characteristics of parole system, rules which regulate parole system in variety legislations. And later we shall discuss the types of conditional release. In previous lecture, we discussed probation, and we said that probation is a sentencing alternative available to judge. Again, probation is a sentencing alternative available to judge. So, probation considered an alternative, not penal treatment. That's the first difference between probation and parole. Second difference, okay, decision which probation issued by judge in verdict. Why? Conditional release, parole, administrative or relevant administrative authority issue its decision. So probation is a sentencing alternative available to judge, except in those cases in which mandatory incarceration is specified by law, depending or based upon jurisdiction. Some or all of the following characteristics are considered as constituting the operation of probation. First one, there is a sentencing alternative that postpones final adjudication. Do you remember when we discussed probation as an alternative? We said that there is twice type of probation: probation with and without adjudication. A judicial function wherein the court retains authority. Incarceration in such case is avoided and replaced by probation, as probation considered an alternative. So probationer remains at liability in the community. Hmm, subject to court imposed conditions. Probationer is placed under administrative supervision. Probation officers of probation officers. Probation may be revoked if conditions are violated. And final sentence is in such case shall be issued. So probation is desirable. Disposition in appropriate case because it maximizes the liability of individuals while at the same time vindicating the authority of law and effectively protecting the public from further violation of law. If affirmatively promotes the rehabilitation of the offender by continuing normal community contacts, it avoids the negative and frequently certifying effects of prison sentence, of confinement, that often severely and unnecessarily complicate the Reintegration of the offender into social fabric, into the community. So it greatly reduces the financial costs of public treasury, treasury of an effective correctional system. And it, on another hand, it minimizes the impact of the conviction upon innocent dependents of the offenders. So probation developed as an effort to mitigate the harsh penalties of early law. And we said also the rules which regulate guaranteeing probation. We said that authority to grant probation resides ultimately with the court. This decision or verdict is a sentencing alternative. The person doesn't, or probationer doesn't have a right to be placed on probation. Rather, probation is a discretionary power, discretionary decision of judge who may or not consider recommendations such as uh, pre-sentence reports. On most jurisdictions, there are laws that govern liability for probation. Typically, in some cases, probation considered when a capital offense is not involved. A defendant in such a case were not likely to commit another offense, or incarceration is not mandatory. In general terms, probation has been more likely to be granted to the first-time offenders, not recidivists. First-time offenders who has committed less serious offenses. That's the rules, conditions which regulate granting probation. Although probation is used for both felony or misdemeanors or violations. Increasing number of felony offenders are being placed on probation oftentimes as a result of their burdening. The fact of prison overcrowding, hmm, overcrowding may many times becomes a factor of bargaining process and subsequent. So regarding two probation conditions or required conditions for granting probation, the purpose of probation is to assist offenders in making social adjustment, reintegrating them into the social fabric and society as law-abiding citizens. Therefore, the policy in such a case has been to impose restrictions on the freedom of the offenders or probationers. Such restrictions differ from jurisdiction to another, but some are common to all, depending upon jurisdiction. The variety of conditions probation may be imposed on offenders' behavior or mobility, includes rules regarding supporting dependents, owning an automobile, usage of alcoholic beverages, a changing place of resistance, mm, a changing job, mm, and maybe something else. Certain behaviors might be prohibited. Certain behaviors might be prohibited, such as liquor consumption or possession of a firearm or other conditions supporting independence, probationers are required to report to an officer periodically at a specified time and places. Officer or relevant officer in such case may visit client too. Probationers may change their resistance only with uh, permission of supervising officer. They must walk or to attend school or some other approved activity. If those plans are changing, the changes must be reported. In some cases, they will not be allowed to make changes. Any changes in life and their livelihood without prior permission of the supporting officer or the court. It depends on the rules which set by the law. Probationers may require to report to an officer periodically at specified times and places. Officer may visit the client too. Probationer may change residence only with permission of supervising officer. They must work or attend to school or other approved activity if those plans are changed, and changes must be reported. In some cases, they will not be allowed to make any changes without prior permission or of the supervising officer or court. Generally, probationers are required to submit periodic reports to their activities and progress. They may be restricted in the usage, for example, alcoholic beverages and appearance in bar or other questionable places, and they may be required to submit to periodic drug testing if the facts of their cases suggest drug violations. They are not permitted to use, or they may be permitted to use drugs. Also, they are not permitted to own or possess or to use or to sell or to have under their control deadly weapons or firearms. In some jurisdictions, probationers are not permitted to drive and cars, to drive cars, or in other jurisdictions, driving probationers are not permitted to permitted to driving and permitted only with prior permission or of the supervising officer. Normally, they are not permitted to leave the country or the state which they already resides without permission. Such permission is granted infrequently and only for extraordinary reasons. Probationers also are required to refrain from violating laws, and they must cooperate with the probation officers. That is a symbol of the conditions. In some cases, curfew or restriction on where they may live are imposed. There are civil rights may be affected as well. Usually, they are permitted to marry, to engage in business, or to sign contracts without permission. Many jurisdictions require probationers to pay fees to cover a part of costs of probation services. The purpose of the rules is to aid person in living law-abiding life in the community. However, the examination of conditions imposed reveals that some are related to a treatment philosophy, while others emphasize a more punitive or controlling orientation. Thus, another correctional issue arises over the best conditions to achieve a desired outcome, law-abiding people. APA or American Bar of Association, American Bar Association has provided some guidance by suggesting areas where conditions can be helpful and appropriate. They are as follows. One, cooperating with a program of supervision. Two, meeting family responsibilities. Three, maintaining steady employment or engaging or refraining from engaging in specific employment or occupation. Five, pursuing prescribed educational or vocational training. Six, undergoing available medical or psychiatric treatment. Seven, maintaining residence in a prescribed area or in a special facility established for or available to person on probation. Eight, maintaining resistance in the prescribed area or in a special facility established for or available to person on probation, and undergoing available medical or psychiatric treatment. Also, refraining from uh, consulting with certain types of people or frequent certain types of cases. Also, making restitution of the fruits of the crime or reparation for the loss or damage causes. So, هنا الاختبار القضائي يختلف عن نظام البيرول. البيرول والكونديشنال ريليز والايرلي ريليز دي اساليب معامله عقابيه. الغرض منها غرض اصلاحي مش بونيتيف، يعني دي ما بتعتمدش على البونيتيف ايديولوجي ولكن الكوركشنال ايديولوجي. واللي بتقوم على فكره او فلسفه ان انا ما اطلعش الراجل من السجن مره واحده او من الحبس مره واحده او من المؤسسه الاصلاحيه مره واحده عشان ما يحصلوش صدمه زي ما كنا بنقول في المحاضره اللي فاتت. ما تحط ايدك كده في الديفريزر هتتألم شويه، بعد كده بعد شويه ايدك هتاخد على البروده. لما تاخدها مره واحده وتحطها في ميه سخنه ايه اللي هيحصل؟ هيحصل لك شوك. هو ده اللي بيحصل برضه لما تجيب السجين من التوتال ريستراكشن الى فول لايبرتي. اوكي، عشان كده الفلسفه العقابيه في اساليب المعامله العقابيه ان انا اخرجه للمجتمع جرادولي يوم يحصل ري انتجريشن. لكن البروبيشن لا، ده نظام مختلف بيعتمد على انه بدل مواقع العقوبه او بدل زي ما اتكلمنا قبل كده له كذا نظام without or with adjudication، يعني كبديل لاجراءات التقاضي وكبديل للعقوبه، بديل مش اسلوب معامله عقابيه. طيب، ازاي بيتم منح الاختبار القضائي؟ سلطه الاختبار القضائي او منح الاختبار القضائي ده بحكم محكمه وبيعتبر حكم بعقوبه بديله. اما في البرول بتاعي عشان نقول ان هنا ايه الميجر ديفرنس بين بيرول اند بروبيشن. في البيرول لا، ده مش بديل، ده اسلوب المعامله العقابيه. بيصدر اول حاجه، تاني حاجه بيصدر قرار من السلطه التنفيذيه المختصه، مش من القاضي. ده فين؟ في البرول او كونديشنال ريليز. هنا بيصدر من القاضي او من وكيل النيابه على حسب النظام. كمان مفروض ان في اجريمنت في البروبيشن، واحنا اتكلمنا عنها في البروبيشن وزاره الادجكيشن في الالترا. ديل كده بيعمله، بيمضي عليه. لو هو وزاره ادجكيشن، يبقى الاجريمنت هنا بتتضمن اقراره بالمسؤوليه الاخلاقيه مش القانونيه، لان لسه بتحكم، بالاضافه الى شروط معينه يجب انه يلتزم بيها. طيب، ده عشان يكون في liability للبروبيشن. عندي كمان رولز وبوليسز وكونديشنز obliques he obliques to follow عشان يضمن استمرار خضوع لاختبار قضائي، اللي من بينها انه يعني لو يشارك في برامج اصلاحيه زي برامج خاصه بعلاج الادمان وهكذا. وبالتالي الاختبار القضائي يمنح من المحكمه عكس البرول اللي بيمنح من السلطه التنفيذيه. في معظم التشريعات في قوانين بتحدد تفصيلا الشروط اللي بتخلي في liability للبروبيشن. واللي من بينها انها ما تكونش جريمه، مثلا جريمه جنايه، لازم تكون وطبعا دي بتختلف من تشريع لتشريع. لازم تكون جنحه، ما تكونش العقوبه الاعدام مثلا. اوكي، لا، تكون عقوبات جنح وهكذا. هنا الامر بيختلف على حسب التشريع، الشروط بتختلف على حسب التشريع. طيب، ايه اهميه الاختبار القضائي؟ اولا بتوفر الكوستس، بتوفر تكاليف، تقاضي تكاليف العقوبه. بتقلل لي الكراودنج اللي هو بيحصل في السجون. اوكي، بتساعدني انا كدوله ان انا اعمل برامج اصلاحيه للاشخاص اللي محكوم عليهم بعقوبات طويله المده وهكذا. طب ايه شروط الاختبار القضائي؟ الشروط زي ما قلنا بتختلف من تشريع لتشريع. وشروط زي ما قلنا متعلقه بالعقوبه، متعلقه بالهيستوري بتاعه. يعني ما ما يكونش ريسيدفست، ما يكونش عائد لارتكاب الجريمه. كمان شروط ثانيه لم عشان يضمن استمرار الاختبار القضائي. اولا ان هو يلتزم، لو هو في محتاج برامج معينه زي علاج الادمان، زي العلاج النفسي اللي هو الانفولنتري، اللي هو الانفولنتري ثيرابي. اوكي، يخضع لها. انه لو هو يؤدي التزاماته الماليه على حسب هنا التشريع، انه ما يظهرش او ما يصاحبش اصحاب السوق، انه ما يشربش الكحول، على حسب هنا التشريع وعلى حسب الاجريمنت اللي هيبقى هو هيوافق عليه، او الشروط اللي هتفرض عليه في هذه الحاله. الاي بي اي او نقابه المحامين الامريكيه قدمت بعض الارشادات في هذا الشان. قالت ان هو شروط ممكن تكون ان هو يتعاون مع البرامج الاشرافيه، ان هو يوفي التزاماته العائليه، انه يكون له عمل ودخل ثابت، انه يؤدي عمله او يؤدي دراسته لو كان طالب، خضوع للعلاج الطبي لو كان هو محتاج علاج طبي او نفسي، انه يقيم في منطقه معينه، انه يمتنع عن مخالطه رفاق السوء، انه هو يعوض المضروب من الجريمه. وزي ما قلنا دي بتختلف من حاله الى حاله، ومن تشريع الى تشريع. وداخل نفس التشريع بيحط الشروط، وهنا السلطه المختصه اللي هو القاضي او وكيل النيابه على حسب هو without ولا with adjudication، هو اللي بيحدد هذه الشروط. طيب نتكلم بعد كده عن revocation of revocation of uh, probation. ال 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 الباوربوينت ظاهر عندكم السلايدز؟ ظاهره السلايدز يا اولاد؟
اه يا دكتور زهر.
طيب 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 هنتكلم بعد كده يا اولاد على revocation of probation. Once granted, probation is granted, court may take back or withdraw the dispossession of probation. Such action constitutes constitutes the revocation of probation. Probation may be revoked for two reasons. First one, breaking law. Second one, breaking of the rules of granting probation. Again, probation may be revoked in certain cases. Breaking law and breaking of rules for granting probation. Rules, in which case a technical violation is said to have occurred. For example, if the probationer breaks the rules that requires permission from a probation officer to go to travel outside the jurisdiction, then a technical violation is okay. Such behavior is not a violation of law, but a violation of one of the rules, required rules, or the rules hmm, which, or the rules for granting probation. In most instances, revocation is more likely to be requested and granted when another, when another crime has been committed, such as right violation, rather than for technical violation law. Revocation represents an important decision since the professional will then likely face a term of incarceration or a criminal penalty. The hope for successful reintegration dashed, has been dashed, and the state is faced faced with increased cost of imprisonment. What about probation supervision? One of the primary functions of probationer officer is to supervise probationers. The type and degree of supervision vary according to according to the rules. In some probation departments, Okay. So a new prison arrival is not only informed of their fixed liability date, but also but also the date or days when release on parole is most likely to occur. The probability range is a span of time during which the inmate may reasonably expect serious parole consideration. Such range is calculated based upon the discretionary power of discretionary paroles granted in the previous 6 months to inmates with similar offenses, sentences, and personal characteristics. It is important to recognize that in none of these cases does the inmate have uh, uh, granted parole date. The release liability date is only the first time parole consideration is given. Usually, the offender, particularly repeat offenders, recidivists, recidivists, are not released at the first parole hearing. The probability, the probability range is just that a time period when parole release is probable but not assured. Parole is discretionary and can be granted throughout a settled, presumed period of sentence. Indeterminate sentencing jurisdiction and exact release date subject only to good time provision could be established at the time of the individual sentencing that the date would constitute granted. And uh, إصدار القرار إصدار القرار بالprobation أو البرول له certain requirements بالنسبة بالنسبة للنظام البرول بيكون وده يمكن عكس الكونديشنال ريليز بيكون قبل المدة البينية بمعنى انه هو في البداية بيحدد بيحدد آه بيحدد له المدة. وعلى سبيل المثال يعني بعض القوانين اوكي بتحدد مدة بينية محددة مسبقا. يعني مش زي الكونديشنال ريليز بتتحدد بعد قضاء فترة من العقوبة. ودي ممكن تختلف من شخص، لا دي بتتحدد في البداية. دي بتتحدد في البداية، بيبقى عارف من البداية هو هيفرج عنه امتى. اوكي، هو هيفرج عنه امتى. طيب أم، وفي ناس ما بيكونش عندهم الابيليتي في للبرول زي يعني اللي عندهم سوابق قضائيه. نيجي للبرول بلان and jurisdictions where there are requirements for administrative approval of the release. Some steps are typically taken prior to the parole hearing. The first of this is to develop a parole plan a few months prior to an inmate's fixed liability date. A pre-parole interview is conducted. Such interview conducted by institutional parole officer, parole officer begins the parole release consideration process. Typically, an inmate has already become fully informed as to the various parole procedures through discussions with other inmates or correctional staff members. Nevertheless, officer will briefly review the step and the answer any question an inmate may have. Inmates are given a parole planning from to be completed and returned to officer prior to any further consideration. In some cases, officer or other institutional staff members have the opportunity to provide valuable guidance to inmates who are attempting to formulate parole claim. This is a time when an individual is faced with reality of returning to the community, free community, and making sometimes difficult decisions about his or her future. In certain cases, even the hardest of all goals could be reached by correctional staff members during this phase of incarceration. The two most important aspects of parole plan are the place of resistance and employment. Both of these factors require contacts on the streets, which may be limited or unavailable to some inmates who have been incarcerated for many years. When jurisdictions were asked to rank the amount of influence of parole plan or crowding community resources had on release decision, a parole plan was ranked as most important. Parolees often face many adjustments and uncertain futures features when returning home. أم، عشان يفرج عنه، احنا زي ما قلنا المفروض ان في اجريمنت، في بلان، والبلان دي بتتحدد فيها الخطوات والستبس والشروط اللي هو يجب ان هو يلتزم بيها عشان يستمر تطبيق نظام الفيرال. البلان دي بتختلف على حسب طبعا التشريع، وعلى حسب دراسة الشخصية نفسها. وممكن تغيير البلان دي والكونديشنز دي اذا ارتأت السلطه المختصه ان هناك حاجه لهذا التغيير. طب ايه هي البيرول كونديشنز؟ كونديشنز او conditions of parole established for parolees behavior upon release vary greatly among jurisdictions. Okay. A typical special condition might be a requirement that barely seeks assistance in dealing with substance abuse problem. Each party must agree to such conditions detailed in the party agreement prior of being released. There was a time when parole authorities were given almost unlimited uh, discretion to establish condition of parole with the uh, advance of incarcerated level civil rights of prisoners or and parolees limits have been placed on the range of conditions of parole. Parole conditions vary from according to jurisdictions from jurisdiction to another and are similar to probation conditions. Many parole conditions have been challenged in court. They are valid. However, if they are legal or moral, and if it is reasonably possible for the parole to comply with them. The general rule is that conditions of parole must be reasonable and have some justifiable application to an individual situation. In most conditions of parole that limit free speech require church attendance or mandate surgery or considered unreasonable by present standards. One typically written condition of parole relates to the parolee's protection against search and seizure. The court have ruled that a search that would be unlawful if directed against ordinary citizens may be probable, probable if conducted against parole. Courts have generally required a lower standard of proof to justify warrantless searches and arrests in the cases of parole. الشروط احنا قلنا الشروط بتختلف يعني تقريبا هي نفس شروط probation وبتختلف من تشريع لتشريع وبتختلف من حالة إلى حالة. القاعدة العامة إن شروط البيرول يجب إنها تكون معقولة وإن هي طبعا يعني بتتوافق مع شخصية أو ظروف الخاضع لهذا النظام. طيب ده بالنسبة للشروط. نيجي بقى للريتيرن كوميونتي from the offender's perspective. Parole and other conditional release represent more than just legal restriction, since this help to define his or her social status. Social status. There is a clear stigma attached to being a parole. A label identifies an individual as loser, one who must be watched carefully and not be trusted, and not be trusted. Not every individual or parole or individual released from prison encounters such negative reaction, but stigma, which concerned with, do you remember extra-legal penalties, may remain in both the minds of public and the minds of parents. The support of family, friends, and other significant individuals in the community is also a crucial factor in parole success. The individual who returns to the community without established ties in the face is faced with yet another problem. Everyone needs the support by carrying others, but often the parole must face a new life without these key resources. Maintaining regular community ties with significant others while incarcerated may be one of the most important activities in which an inmate can become involved. The stress and the challenges facing the parole and returning to the community are numerous. Individuals' self image, and attitude in many cases help him or her to make it past those first months in parole. Numerous studies have indicated that the highest rates of parole revocation occur during the first 6 months after release. Parents may find especially difficult to adjust to a wife, to a family, to upon the release from prison after an absence of several years. Family has probably become more independent and learned to function without the incarcerated individual or parent. During such early months, many adjustments must be made by the parent. Typically, during such period, individual would be under maximum supervision and have the greatest contact with the parole officer. At such stage in the parole process, the BO could provide the support of encouragement along with supervision that may make a difference for some parents. طيب، هيقابلنا هنا مشكلة في إعادة الشخص ده لما يرجع تاني حتى في نظام البارول. أوكي. وخصوصا فيما يتعلق بالاستجمة بوصمة العار، ما هو كان في مؤسسة إصلاحية أو كان في السجن، فبالتالي هو اكتسب وصمة العار، وبالتالي احنا هنخش تاني في مساحة الاكسترا ليجال بينالتيز. طيب، هنا هتقابلنا مشكلة، لأن هيحصل عليه ضغوط من المجتمع اللي هو هيطلع من المؤسسة الإصلاحية عشان يندمج ليه جرادولي. هيخش لأسرته، هيلاقي أسرته أصبحت أكثر اعتمادية على نفسها، فبالتالي هيلاقي نفسه مش دي الأسرة اللي كانت بتعتمد عليه. السمت بينه وبين أفراد المجتمع وبينه هيبقى أقل. الاستجمة، وصمة العار هتبقى برضه موجودة. إذا نجاح هذا النظام هيتوقف على إزاي هنقدر نستوعب أو المجتمع يستوعب هذا الشخص مرة أخرى. طيب، انتهت فترة البيرول، هنا بيتحول الامر من conditional release الى final release. Whether one examines the repeat offender or first time parole correction factors help to determine parole outcomes. Most positive possible outcome is final release. Final release received generally in 2 years or less ends individuals' legal obligation for conviction. The term parole success generally refers to to accept the final release and thus the termination of parole. Regarding to parole officer supervision, similar probation officer supervision, parole officers are representative of the criminal justice system responsible for supervision of conditional parole or condition release. Supervision in such a case is a POW term used to describe the various tasks that parole officers is required to perform, is required to perform. The two available to parole officer include the legal authority of the office, communication and counseling skills, community contacts, and other resources. The relationship that develops between parole and parole officers is largely dependent upon two factors. The first one, the attitude of parole. The second one, the parole officer, attitude of parole officer. There are different styles and approaches taken by parole officers. The same range of differences could be found among parents. The relationship, the relationship can range from close and trusting to hostile and distant. From the parole perspective, type of relationship that develops can be important in determining parole success. Tasks of officers may be divided into four basic categories: intervening, investigating, enforcing, and helping. Each category of task is present in most parole officers' assignments, although the relative importance varies greatly by jurisdiction and among personnel. Regarding to revocation of parole, similar revocation of probation, unsuccessful parole occurs with revocation of parole and the release is returned to incarceration or parole violation. Criminal violation occurs when the release is found guilty for breaking law. Technical violation occurs when it has been determined that parole has violated condition of parole and parole and would not be considered a criminal conviction or non-parole. An example of a technical violation would be parole who is restricted from leaving the state and found to be visiting a relative in a nearby state without the permission of parole officer. Also, traveling between states is not against law for a free citizen, but it violates the condition of parole and thus is a technical violation. Technical of a criminal violation could result could result in termination of parole and a return to prison. Such violations don't always result in a revocation of parole, but the option is available to parole authority. Revoking parole is discretionary decision, which is ultimately the responsibility of paroling authority. The area of court intervention that had the greatest impact on the operation of parole has been revocation. Code established limited due to process guidelines for parole revocation. Court um, differentiate between the parole release hearing and the revocation hearing. The release hearing was viewed as a discretionary function of correctional agency, but the revocation hearing was seen as a quasi judicial or legal setting. Difference between both of them. The two rests on the fact of revocation of parole results in significant deprivation of liberty, while the parole hearing was viewed as an administrative decision-making process to determine whether or not to continue a status as an inmate who had no liberty interest to say. امتى بتلغي نظام البيرول لما بيخالف، وزي ما قلنا في نظام البروبيشن بيخالف، يا اما بيخالف القانون يا اما بيخالف شروط البيرول او شروط هنا الاخراج المشروط في هذه الحاله. على سبيل المثال، يعني زي ما كنت بقول في المثال من شويه، يعني اذا كان الشخص العادي ممكن يسافر عادي جدا ما فيش مشاكل، لكن الشخص الخاضع لنظام البيرول ما ينفعش يسافر الا بقرار من البيرول بورد اوفيسر. طيب الاورجنايزيشن اوف payroll system organization of payroll is complex. One reason for complexity is the variety of sentencing structures under which payroll system must operate. Sentencing structure is related to payroll system in jurisdictions where sentence as long with little time of for good behavior payroll may involve a long period of supervision. In jurisdiction where sentences are short, payroll may be uh, unimportant as a form of release, and supervision is for shorter period. Regarding to payroll guidelines or risk assessment, a principal change has been changes made in risk assessment guidelines by which to make payroll decision. The goal is to increase fairness and reduce uh, disparity. Some guidelines seeks to develop predictions on a statistical basis that's given certain set to risk factors. What's the probability for success of on the severity of criminal history is one major factor taken into consideration. Also, the risk factors such as early crime, age at present offense, drug usage, and early incarceration are also involved and evaluated. فيما يتعلق بتقييم مخاطر الافراج بالشغل، لان طبعا البيرول ممكن يشكل خطوره على المجتمع، لان انا بطلع شخص ممكن بمنتهى السهوله يرتكب جريمه. فبالتالي هناك بعض الضوابط اللي بتتخذها المجتمعات المختلفة، واللي بتضمن ان يفضل معدلات ارتكاب الجرائم هنا في اقل درجاتها، وبالتالي الخطورة اللي متوقعة من هذا الشخص تبقى في اقل درجاتها. هذا فيما يتعلق بنظام البيرول. هنيجي نتكلم بعد كده على الكونديشنال ريليز او الايرلي ريليز از سبيشال فورمز of يعني early release as a special forms of conditional release. فهنتكلم على الامرجنسي ريليز والسنتنس ريدكشن والايرلي بيرول. قبل ما نتكلم على البوينتس دي الاخيره، لو حد عنده